Hello friends, in the series on the income tax cases, today we will discuss an issue where some excise department finds some cash with an assessee when the assessee was travelling in a bus and produces that cash before the magistrate, and the assessee claims that amount before the magistrate that this cash relates to me, and at the same time the income tax department also come before the magistrate and says that this cash should be given to me under section 132A, which talks about power to requisition books of accounts, etc. The question before the Kerala High Court in the present case was that whether the magistrate is empowered to release the cash in favor of the revenue when there is no outstanding demand of the assessee. This issue has been taken up by Kerala High Court in a criminal miscellaneous application filed by the assessee in the court, and the name of the case is Ravirajan and Others versus State of Kerala. This matter has been reported in 471 ITR at page number 131, and the date of the judgment is 26th September 2023. The facts of the case are very interesting. In the present case, on 8th October 2022, the employee of the assessee was travelling in a bus, and that bus was searched by the Excise Circle Inspector, and that inspector found an amount of rupees 40 lakh cash with the employee of the assessee. The employee of the assessee was not able to give the proper explanation of that cash, so that cash was produced before the jurisdictional magistrate along with the report. The assessee also went to the court and said that this cash belongs to me, and he took the ownership of that cash and said that this cash should be released to me. And at the same time, the income tax department also went to the jurisdictional magistrate and said that under section 132A, this cash should be given to me, that is power to requisition books of accounts, etc. The magistrate passed an order in which it was said that this cash is to be given to the income tax department, and the income tax department is directed to complete the proceedings of assessment within 6 months. The assessee challenged this order by filing a criminal miscellaneous application in the High Court, and when this matter was heard by the court said that the excise department closed the proceedings against the assessee and didn't find any wrongdoing on the part of the assessee. The court said that if cash is deposited in the court, then requisition under section 132A cannot be done by the income tax department, and the cash should not be given to the income tax department. The court said that in the present case, the advantage of finding of the cash with the employee in a bus by the excise department is that the assessee has come itself forward to claim that cash. The court said that in the present case, the revenue is grossly failed to prove that there is no outstanding demand on the part of the assessee, so that cash cannot be requisitioned by the income tax department for any anticipated tax dues or interest due or penalties which may come in future. The court said that the income tax department has a liberty to issue the notice to the assessee under section 147 and complete the proceedings, and directed the income tax department to hand over this cash to the court, and then the court will give this cash to the assessee. At the same time, the court also put a stipulation that there should be two sureties of rupees 40 lakh each while this cash is to be given to the assessee. So there was a safeguard for the revenue also. But nowadays these type of cases are coming because whenever there is election in some states, and when the department finds some cash, any of the authority, it may be police authority, it may be custom authority, it may be airport authority, it may be railway authority, railway police. So this case is very helpful in all those cases where the cash has been seized by some other authority, and this cash is handed over to the income tax department. At the end of this video, once again I am repeating the name of the case. The name of the case is Ravirajan and Others versus State of Kerala, and this case is reported in 471 ITR at page number 131, and the date of the judgment is 26th September 2023. Thank you, friends.